Good afternoon, and I'd like to welcome everyone to the April 18th, 2022 meeting of the Senate Judiciary Committee. We're going to start the day by opening the public hearing on House Bill 266 and call the prime sponsor, Representative McGuire. Good afternoon, Representative McGuire.
Good afternoon, Madam Chair, Senators. I'm Carol McGuire, representing Merrimack District 27, which is Allenstown, Dunbarton, Epsom, and Hooksett. And I'm also the chair of JILCAR, which is why I brought this to your attention. This is a request of the JILCAR staff. And what it does is that it gives the notice and public access requirements for hybrid or virtual hearings on rules. It does not, in and of itself, allow them to hold virtual or remote hearings. That's another bill, and it just says what the requirements are if you choose to hold one, if you're so authorized.
Mm-hmm.
This is essentially a recodification of the emergency orders from the governor's executive orders. And so it's been checked out. It works pretty well. And if you have questions, I'll try and answer them.
Okay, thank you for your testimony. Are there any questions for Representative McGuire? Representative, I just want to, I want just to be clear on this. This is not authorizing them to hold hold Zoom meetings or electronic meetings. It just sets up the parameters if at some point in the future there would be a need to do these.
Yes, that is correct. There is, I believe, a House bill that you'll be seeing later that does authorize this sort of meetings to be virtual. But this is clear, this is just, given that you're holding a virtual or hybrid meeting, these are the steps you have to go through to ensure the public has full access.
Okay, thank you. Are there any questions? Seeing none, thank you very much,
If you'll excuse me, I've got.
Pardon?
If you'll excuse me, I've got
Yep.
another.
I'm sure you're very busy. Thank you. Are there any other members of the public that would like to speak to House Bill 266? Okay, seeing none, we'll close the public hearing and the committee will be in recess for about 12 minutes. The committee will come out of recess and will open the public hearing on House Bill 343 and recognize the prime sponsor, Representative Schmidt. Good afternoon, Representative.
Good afternoon, Madam Chair and Senate friends. I am pleased to be here in support of House Bill 343, which I am bringing to you at the request of one of my semi-constituents. She is not technically in my district, but she and I worked together for a number of years on issues involving the disabled and people who are, for example, in the secure psychiatric unit at state prison. And she has become very knowledgeable about the situation and brought it to my attention that the statute, in her opinion, is defective in a number of ways with regard to the issue, the subject of the bill. I'm not going to get into the details because I have several supporters here in the room who are extremely knowledgeable in this area, including the chairman of the House Judiciary Committee. So I strongly recommend it to you, and the two attorneys who are here and also in support can get into any details, but I strongly recommend the bill to you and request your support for its passage. So thank you very much.
Thank you very much, Representative. Are there any questions from the committee? I just have a quick question. Maybe you can answer it. So the way that I read this, it says that a person who is appointed a guardian shall retain the right to access their medical and other confidential records unless the court specifically finds it would not be in the ward's best interest to do so. So I think maybe I'll give my question to the chair of the House Judiciary.
I am aware of the issue that you're raising, and I think that my supporting colleagues here will be able to answer the question in the depth that you need. So
Yeah.
thank you for that.
Thank you. I thought it was, to aid the ward in getting the records, but it's maybe a little confusing, and maybe the chair of House Judiciary can clarify that for me.
I'm sure he can. Thank you.
Thank you. The chair will call Representative Lynn. Good afternoon, Representative. You're the pinch hitter for the day.
I'm Representative Bob Lynn from Wyndham, and I appear in support of HB 343. I think this bill, as proposed by Representative Schmidt, and I believe Ms. Rosenberg will be here to kind of give the committee more background. But I think in essence, what this bill does is to say that the records that a ward wants, the ward should be able to get unless the court has determined that it would not be in the ward's best interest to get the records. So in other words, I guess in a sense, it's just like the current law says that when a ward is appointed a guardian, the ward retains various rights unless the court has said, no, the ward doesn't have these rights, like the right to marry or the right to own property or whatever. And it seems to me that what this does is to say, well, among those rights that the ward retains is the right to get access to the ward's medical records or banking records or whatever, unless the court says, no, there's some reason it would be detrimental to you, ward, to be able to get access to those records. And so I think that that's the way I read it. And there are, it's, you might say to yourself, well, if it's just doing that, why is it 2 pages long or whatever? And the reason it really is that there are several sections that it's necessary to say that kind of thing. But essentially, that's what this bill accomplishes, I believe.
Okay, thank you, Representative. Are there any questions from the committee? Representative, as you know, last biennium, we passed a new guardianship bill. And in that bill, it gave the ward a little more power to determine what they wanted guardianship for. And I'm wondering if this is something that would be included, that a ward can say at the time of the awarding of a guardianship of somebody, that they can say, I want to get access to my records, whether it's medical records or any other records. Do you see this then fitting in with that and something someone can do at the time of the guardianship?
Sure, I believe that's right, and I will let Ms. Rosenberg, who knows a lot more about guardianship generally than I do, but I believe that if there's another section of the guardianship laws that talk about what, when a guardianship is first established, what the ward can ask be sort of excluded from the guardianship, in the sense that the ward would continue to have the power to make his or her own decisions regarding those things, then I would think, yes, that the ward could say, look, I agree, I need a guardianship for a bunch of things, but I think I should still be able to decide whether I'm going to get married or not, as an example.
Right.
I think I should still be able to hold property in my own name, as another example. And also, I would think the ward should be able to say, and look, I need a guardianship for whatever reason, but I'm not, so, for lack of a better word, disabled, that I shouldn't be able to get access to my bank records or my medical records. And so, Judge, when you enter the order of the guardianship, please make it clear that I retain the right to get access to my bank records or my medical records or whatever. And so, yes, I think the answer to your question is yes. I think the ward could do that right at the outset when the guardianship is first established.
Okay, thank you. Are there any further questions? Okay, seeing none. Thank you very much, Representative.
Thank you.
The chair will call Karen Rosenberg and Ms. Tasker. They requested to come up together. The only thing that I would request is that when you testify, that you give your name, so that way our committee secretary can maintain the accuracy of your testimony. Thank you.
I'm Karen Rosenberg. I'm the Policy Director of the Disability Rights Center.
And I'm Carrie Tasker. I'm an attorney here in Concord. I do a lot of guardianship work for both guardians and for wards. So I bring with me my experience in doing that.
Okay, for the stenographer, this is Karen Rosenberg. So what this bill is attempting to do is address some gaps that have resulted in some inadvertent removals of the right that people who end up under guardianship have to access their records. So under the way that our guardianship law is currently written, it enumerates a number of types of rights that a court may decide to must be taken away, like right to marry, just as Judge Lynn mentioned, but is silent on two issues. One is whether the proposed ward would have the right to access their own records, and whether the guardian needs to have access to those records. So, of course, almost universally, I can't think of a situation when they wouldn't. The guardian who's appointed needs access to the ward's records to do their job. But what can happen is that what happens is that inadvertently, in ordering that the guardian needs to have access, the courts are inadvertently simultaneously removing that right from the proposed ward. It happens with one click of a pen. And so what this does is it makes it clear that if the court determines that the determination of whether a ward continues to have access must be determined separately from whether the guardian also has access. And a ward might need access to the records for a bunch of reasons. One might be they want to review medical records so that they're making sure they're following doctor's orders, like diet, exercise, stuff like that. Or that they're trying to work on budgeting issues, and so they want to keep track of their banking records to see how they are managing some of their personal funds. So that's the first thing that this bill would do, and those would involve decisions at the outset of a guardianship. And then it would also address a situation we see in our office quite frequently where the order may be silent about this, but guardians, and it happens mostly, I think, with private guardians, are really slow to award their records if they request them, even if they're allowed to have them, or slow to sign a release so that our office could get records. So what this does in Section 2 is provide a time parameter, do it within 10 days. So it doesn't require them to produce anything they don't have, but in Section 2 it says if you've got it, there's no question that your ward is entitled to have access to the record, you need to give it to them in 10 days. There's a safeguard in that provision so that if the guardian sees this and realizes, oh no, this is actually going to be really harmful, the guardian can seek a court order to modify the guardianship in order to prevent the disclosure of records that would be harmful. So that's in Section 2. Okay. Do you want to go on and talk about I feel like I'm hogging the microphone here. Sections 3 and 4 deal with situations where the order has already been entered. So for example, like the change in the findings would only apply prospectively. So there are probably more than 6,000 people under guardianship right now who don't have specific findings about whether they can secure access to their own records or not. And what sections 3 and 4 do is provide for the situation where someone is under guardianship and might want to seek either a modification of that guardianship, a termination, perhaps because they're no longer incapacitated, or maybe even seek a different guardian because of issues they're having with their current guardian. And it would allow them to get access to those records if they first file a motion with the court, telling the court what it is that they're seeking, modification, termination, swapping out the guardian. And it provides a process for guardians to object to providing those records if need be, if it would be harmful to the ward's interests. But otherwise, it would provide an opportunity for the ward to secure those records before they're too far into any kind of litigation and could review it with an attorney, figure out whether there's a meritorious argument here that they need to have a different guardian or something like that. And it fits in with, I think what you were talking about, Senator Carson, was supported decision-making. So that's actually an alternative to guardianship. So it's not part of guardianship. But one of the things, as you know, courts need to consider is whether there is a less restrictive alternative that will meet the potential ward's needs, less restrictive than guardianship. And so this bill, if it passes, dovetails with that in a bit, that law in a bit, because it would allow folks who are no longer incapacitated or perhaps have made some strides towards independence and capacity to seek modifications of their guardianship or take advantage of supported decision-making. And they might need access to their records to demonstrate the progress they've made.
Okay.
So,
Do you mind if we can
please.
ask questions?
Oh, please do.
Are there any questions? Any questions? Thank you. I do have a question. It seems like if someone who is a ward and has a guardian and they want to get their medical records, say they were at a doctor's appointment and the doctor said, I am prescribing you this medication, and they don't have it, they don't get it for whatever reason. Their guardian is not giving them the medication that they're supposed to be getting. How can they get access to their records? You're asking the person who oversees them to give them access to their medical records. And what if this person doesn't want to do that? Now they have to go to court. they have to file. And that just seems like that's a huge leap here. Just because you have a guardian doesn't mean that you've lost your basic human rights. And that's what I'm concerned about here, is the fact that someone who wants to get access to their records has to go through the very person that might not want them to see those records, and under what types of circumstances. There might be a record of abuse by the guardian in that record. And of course, they're not going to want that exposed. So how can you help this be an easier process for the person who is a ward?
Carrie Tasker speaking. So as the situation is right now, just from my experience, I can tell you that I have never, in my 18 years of practicing, seen a guardianship order that does not remove the ward's right to access their medical records. So in my practice, when I have a ward who wants to obtain medical or financial records, rather, that if they ask their guardian, there are situations where the guardian either ignores it, pushes it off, for whatever reason. Some guardians, I tell you, are great and wonderful, and there are others, there's a whole range that we deal with. And so the person isn't able to access their records directly through their guardian. The next stop for them automatically is right now to have to file something, either a motion to terminate or a motion to amend their guardianship right now. They don't have an avenue other than going back to the court system right now as it is to get those records. So what we're hoping to do is, as Karen said from the onset, is to make it so that the courts need to scrutinize this issue a little bit more to make sure that they are separating the two issues of the guardian being able to have access versus the ward being able, the ward's access being removed, so that the initial order comes out with a little bit more clarity on the issue. When I deal with doctors, when I deal with providers and trying to get the documents, often they will recite the guardianship order and say, see here, it tells you that they can't access their own records. I have had numerous cases, unfortunately, in the last couple of years where this has been a very big issue. And yes, attorneys were involved. There were some abuse issues, but the ward was not able to obtain their own records, and it took us a lot of time through the court system to get access to those records. We're trying to, from the front end, make sure that it's reasonable, that the removal of the right to receive or access records is there, but then also give them a way to sort of wave the flag and say to the court, something's wrong here. I can't access my records. He or she won't give me my records, and here's why I think I should have them. And we put in that when they ask for the records, that there be 10 days that the guardian turn around and provide those records. And if those records aren't provided, that's when the ward can immediately file with the court. So the ward isn't waiting, an extended period of time before, they actually have an answer saying, we're not giving them to you. So you can go ahead and the ward can go ahead to notify with the court. That one is in number 2.
Okay.
On that one, we're just trying to catch the issue from multiple sides, I guess you could say. And at the forefront, the issue is absolutely prevalent that most orders have the restriction that wards can't access their own records.
Okay, are there any questions? Senator Chandler?
Thank you. I just want to clarify. So if we pass this piece of legislation, it would in fact be less restrictive to the wards and give them more agency. Is that correct?
This is Karen Rosenberg for the record. So really what it does is it requires courts to consider and make sure that their orders are accurate, that they have considered whether the ward is incapacitated to the degree that they should not have access to the records. And if not, then they would presumably have access to their own records. So I don't know if it gives them more agency. It actually it comports with what our law requires overall, that there be specific findings when certain rights are removed. It's just that because these particular rights aren't enumerated, they tend to be put together.
Thank you.
And one other thing, just Senator Carson, I think that what you were talking about not wanting to, wards or guardians not wanting to turn in records if there's information in them that may look maybe not a good reflection on them. We can't rewrite the thousands of orders that are out there. I think that what you all can do, though, is address what the law is going forward and what the expectations are going forward.
Senator Abbas has a question.
Thank you, Madam Chair. On lines 18 to 19, it uses the burden of proof as beyond a reasonable doubt. In my experience, I've only seen that in criminal laws. I'm not saying you can't do it outside of that. I'm just asking, is there?
That's actually the burden of proof for guardianship, so it's consistent with what's required under current law.
Not my area of expertise.
That's okay.
Hey, I have another question. How long does it take for someone to file to get access to their records before they're actually appear for a judge?
Well, I would say, this is Carrie Tasker speaking. I would say it depends on which court we're before. Unfortunately, it gets scheduled in accordance with how the court's existing schedule already is. So meaning that if I'm filing in Fourth Circuit, I usually can get in and do a guardianship in a week. I just had one where there were 7 days between me filing the petition and me getting in to actually do a guardianship. So for that particular court, I can get in pretty quickly. But if I am going to, say, the 10th or the 9th Circuit, it's very difficult. I would say a couple months might be a good estimate as to when we can get before the court. So what we were looking to do with this was sort of, because it's such an important issue for it's their own personal legal rights, that we wanted the court to be able to address this issue sooner rather than later, which is why we put some of the time frames in this piece of legislation.
Thank you for that answer. Do you think it would be possible to expedite a hearing that when someone has filed, and that way they're going to get on the docket a lot sooner rather than later?
Yeah, Carrie Tasker again. Yes, I would say certainly if we file a motion to expedite because there's a concern of abuse, neglect, whatever the case might be, certainly it will get before the court. They will look at that. And sometimes even without a motion to expedite, they might look at the sensitive nature of the situation and try to get it on track prior. I do know that guardianships do tend to take a priority over other types of actions in the in the probate court. So they do try to pay attention and address the issues that the wards might be raising. So
Okay, thank you. Are there any further questions? Okay, seeing none, thank you both very much.
Thank you.
Are there any other members of the public that would like to speak to House Bill 343? Okay, seeing none, we will go ahead and close the public hearing. You're all set, Matthew? Okay. We're going to go ahead and open the public hearing on House Bill 315 and recognize the prime sponsor, Representative Filiote. Good afternoon, Representative.
Good afternoon, Madam Chair. Good afternoon, Madam Chair and members of the committee. Representative Sean Filio, and I have the privilege of serving the residents of Cheshire District 7, which covers Keens Ward 2. I speak today in support of HB 315, of which I am the prime sponsor. The bill, as originally introduced in the House, seeks to abolish the gay panic defense in this state and allow New Hampshire to join 16 other jurisdictions which have similarly abolished this morally aberrant practice. As you may know, the gay panic defense is a common law partial defense to murder. It is a provocation defense in which a defendant argues that he was so overcome by a victim's same-sex flirtations that he was temporarily overcome and unable to control his conduct and therefore killed the victim in the heat of passion. The defense turns the law on its head because it engages in victim blaming by pointing the finger at a victim in a homicide case. It says, your life isn't as valuable. And we know that because there's not a straight panic defense. If a woman experiences flirtations that are unwanted from a man, we expect her to act in a peaceful manner. But when a man experiences unwanted flirtations from a man, we begin to say, well, maybe there's an excuse here. As a society, we can do better than that. It is for that reason that since 2013, the American Bar Association has recommended that all jurisdictions immediately abolish the gay panic defense because the defense is manifestly unjust on its face. And the fact is, the gay panic defense has been used nationally. In fact, just last year, in 2022, a Virginia jury acquitted a man who brutally slayed a gay man in a violent rage because that gay man simply flirted with his killer. This incident isn't isolated. According to research by criminologist W. Carson Anderson, between 2000 and 2019, 101 defendants nationwide have invoked the gay panic defense. 6 were fully acquitted, and 42 had their charges downgraded from murder to manslaughter. Put simply, the gay panic defense has worked, and it shouldn't, because it plays on hatred and bias, which have no place in our society. We can do better than bias and victim blaming, which have no place in our state. Since being introduced in the House Criminal Justice Committee, this bill has been amended. It now not only eliminates a provocation defense based on sexual orientation and gender identity, but also does so based on a number of other demographics and identities. I'm proud of those changes. Simply put, no one deserves to be a victim of a crime based on their identity. Demographics are not provoking. We can do better than condone victim blaming, and this bill is a powerful reminder of that fact. I look forward to your questions, and I look forward to joining you in bringing New Hampshire along with the 16 other jurisdictions that have abolished this defense and bringing us into the 21st century.
Thank you very much for your testimony, Representative. Are there any questions from the committee? Seeing none, thank you.
Thank you, committee.
The chair will call Representative Caitlin Kutab. Did I get that right? Oh, all right, hey.
Good afternoon, Senators. Thank you for having me here today. I'm Representative Caitlin Kutab. I'm here today in support of House Bill 315. In 1999, after the brutal and torturous murder of Matthew Shepard, the attorney for Aaron McKinney tried to use the gay panic defense to reduce the charges from first-degree murder to manslaughter. Thankfully, under Wyoming law, temporary insanity or diminished capacity defenses are not allowed. And this was deemed to be the same in effect. We do, however, allow it under RSA 632. In 2018, this defense was used in Texas by James Miller, who stabbed his neighbor Daniel Spencer to death. Instead of being convicted of murder, he was convicted of manslaughter and only served 6 months in jail and 10 years of probation. Similar legislation has been passed in 16 other states, and I feel that New Hampshire should join those other states and seek to protect the community. Thank you. Happy to answer any questions.
Thank you very much for your testimony. Are there any questions from the committee? Seeing none, thank you very much. The chair will call Justin Basoyo. Did I get that right? Okay. Well, I got one right. Sometimes the handwriting's a little hard to read.
I have copies of the testimony too.
Okay, thank you.
Good afternoon, Senator Carson. My name is Justin Bagoyo, and I'm a second-year law student at the University of New Hampshire, Franklin Pierce School of Law. And I'm here in support of HB 315. Currently, a defendant can use their hostility towards a certain group as a defense for provocation to a lesser charge. This is not an objectively reasonable defense because there are certainly other ways a defendant can handle an uncomfortable situation, such as walking away or ignoring the person. Someone being themselves is not an apparent threat, and it's not unlawful. What this is a panic defense, and it's extremely offensive and demeaning to the victim and the victim's family because it lets citizens set their own standards for the permissible use of deadly force. According to the LGBTQ bar, as the representatives mentioned, Massachusetts and New Hampshire are the only 2 states in New England that have this kind of defense. So I just hope New Hampshire chooses to be better and chooses to be on the right side of history. I used to work for the U.S. Attorney's Office for the Southern District of New York as a victim witness specialist. And I'm the first member in my family to go to law school. So my family loves me very much and I matter to them. I have a younger sister who looks up to me. I have a newborn nephew who I look forward to meeting. I have friends who come to me for advice, and I list these things about me because I matter to people. And I should not have to worry about being in danger because somebody just doesn't like who I am. So passing legislation like this gives me and people like me just a peace of mind knowing that our elected officials agree that all lives matter and are equal under the law. And I just want to speak on behalf of the people who probably experience hostility on a daily basis and who aren't as fortunate as I am. They have a community that loves and supports them, and they have family that loves and supports them, so their lives matter too. So I just ask you to please support this bill and pass it out of your committee. Thank you for your time and attention.
Thank you very much for your testimony this afternoon. Are there questions from the committee? Seeing none, thank you very much.
Thank you.
The chair will call Sam Hawkins. Good afternoon.
Good afternoon. Thank you for the opportunity to testify today. My name is Sam Hawkins. I'm the Public Policy Assistant at NAMI New Hampshire, the National Alliance on Mental Illness. On behalf of NAMI, I'm here today to speak in support of HB 315. The basis of our support centers around the intention of the bill as introduced, but we're also perfectly comfortable with the broadening of the bill as amended by the House. Sexual and gender minorities are almost 3 times as likely to be the victim of a violent crime. Though research into this topic is limited, the CDC has acknowledged the prevalence and impact of violence on LGBTQ health. Specifically focusing on youth, the CDC reports that lesbian, gay, and bisexual youth are 140% more likely to skip at least 1 day of school a month out of fear for their safety, and that 10% of these students were threatened or injured with a weapon at school alone. Violence, whether threatened or performed, has a significant impact on an individual's mental health. We believe this impact to be especially great if one does not feel that their safety is properly protected by their community. LGBTQ plus individuals deserve to feel and be safe from harm within their communities, as does everyone else. This bill would take an important step in providing these individuals with a sense of security and a peace of mind in their communities, improving mental wellness. For these reasons, we urge you to vote OTP, and thank you for your time.
Thank you very much for your testimony. Are there any questions?
Thank you very much.
I appreciate you testifying because I think what you're talking about is extremely important. I'm very troubled to see the statistics that you're quoting here from the CDC, that 140% are more likely to skip at least one day of school a month, and 10% are threatened or injured with a weapon at school. If this bill passes, you said it's going to give the gay and lesbian community some sort of security. But how is it going to stop them from being attacked? I'm trying to put the correlation together, that how is this going to stop them? Because if someone's going to attack them, they're going to attack them. It's just, if this passes, they can't use a panic defense. So how do you stop people from attacking them?
Right.
That would be my question to you.
Yeah, thank you for your question. I absolutely agree, and I share the exact same concern, especially since the statistic focuses on youth. I'm not sure that it would be directly impacted by this bill, right? But I was more leaning on it as proof of this violence that does happen. I think other avenues need to be taken to address those specific statistics as well.
Mm-hmm. The reason that I bring this up, women have always had to be careful about what we know, where we go, because we are subject to attack if we're in places and so on and so forth. And we have all these laws to protect us, but it still happens. So my question really is, if we pass this, how is this going to protect the community? They're going to know that if somebody does attack them, they can't use a gay panic defense. But what can we do to stop the attack in the first place? Because everyone has a right to be wherever they want to be and feel safe and not feel that they're going to be subjected to an attack. How do we change that?
I absolutely agree. I think half of it is it's a culture issue, speaking to our communities that these people are welcome and safe and that we will protect them, could prevent them from feeling empowered to harm these individuals.
Okay. Thank you. I appreciate your answer.
Thank you.
Senator Whitley has a question.
Thank you, Madam Chair. And I share that concern as well. But I have a different take about the importance of this bill. And I'm wondering if you would agree that, you don't have to be a lawyer to know that the purpose of a criminal code, the purpose of criminal law is in part to serve as a deterrent, right? If people know that they will be punished. And I see the availability of a gay panic defense, the elimination of that, as yet another tool to say to folks to deter that violence if they know that they won't receive, any leniency based on this panic defense. So I actually see it as a deterrent. So I see a direct link to hopefully one tool in the toolbox to reduce violence as a deterrent. I'm wondering if you agree with that.
I absolutely agree.
Okay. Are there any further questions? Okay. Seeing none, thank you very much.
Thank you.
Are there any other member of the public who would like to speak to House Bill 315? Okay, seeing none, we're going to close the public hearing. Thank you all for being here today. We've completed our work. And again, thank you.